Welcome to Larking Gowen Insights, accountancy and business advice for all, a series that gives you bite-sized tips and guidance on tax, funding, legislation, reforms and much more. With case studies, business advisory and sector specials and even interviews, our team of experts are committed to helping you navigate the world of accounting and finance with a variety of presenters from across our specialisms. So, let's get on with today's show.
Welcome to this special mini-series, Beyond the Barn, the Business of Farming. I'm your host, Laura Clayton, an Assistant Manager in the Farms and Rural Business team. In each episode, I invite a different guest to share their expertise on an array of different business topics that affect the farming and rural community. We cover tax, obviously, legal matters, succession, inheritance, and much more. We go behind the scenes of how we support our clients and hopefully give you some tips along the way. Just a note before we get started. At the time of recording, the inheritance tax guidance had not been released, but we will include a link in the show notes where you can find out more about what has been released since we recorded. And feel free to reach out if you have any questions. So we've got something very different for you today, which is quite exciting. We are going to act out a scenario and do a little bit of role play. So I was joined by Laurie Hill, who is a partner of our farms team, and Jeanette Dennis, who is an agricultural specialist from Ashtons Legal. I'm not going to say too much here, and I don't want to give too much away, but for context, I will be playing the role of one of Laurie's clients that has some concerns over succession planning for the family. The role play is a representation of a conversation that would happen in real life based on a practical case study based on my character. I want to emphasise here that this is a made-up situation, but it is similar to many cases we have dealt with. But as always, this does not constitute officially as advice, and you should always speak to your solicitor and or accountant on any of the topics we have covered in this recording.
Hello, my name is Laurie Hill and I'm a partner in the Farms and Rural Business team with Larking Gowen. Today on this podcast joined by Jeanette Dennis from Ashtons. If you'd just like to introduce yourself, Jeanette, and what your specialism is.
Hi, as Laurie says, I'm Jeanette. I am from a Norfolk farming family. I head the agriculture and estates team at Ashtons Legal, and I specialise in succession planning and farm partnerships for farmers and landed estates.
In today's episode, we are going to be going through a form of role play whereby I'm going to be the existing accountant and we're looking to bring in Jeanette and her expertise from a legal perspective for succession planning for a family. And my colleague Laura will be playing one of the members of the family. So we'll kick off. Laura, obviously we're here today and we've brought together Jeanette into this meeting with us in order to have a bit more of a stab as to where we're going with the succession planning for the family. I think, obviously, with the changes in the budget that took place, or are going to take place in April 26 following announcement in October 2024, it'd be useful just to give a bit of a background, a bit of an up-to-date position of where you are with the family.
Of course. So yeah, we've had a conversation with family and the budget was a real eye-opener. The family want to know what we need to be doing for succession planning, as we've not really got anything in place. I'm not so overly involved in the business. I am a bit of an outsider, so I do have a bit of a different perspective on things. I do oversee the financial side of things, though. Like I said, we do get on really well, which I know is not always quite the case. But the budget has scared us, if we're honest. So we really are looking for a new and proactive solicitor to help us take on some planning.
Okay, thanks, Laura. When I meet people on teams like this the first time, what I tend to do is ask some questions. So are you all right with me covering those with you now?
Of course.
Thank you. And some of these may sound a bit strange, so just bear with me. First of all, it's good that you all talk as a family and that you're aware of the budget. Have you had any thoughts about what are your main concerns?
Well, we actually don't know. We do own some land. It's come from, so we have about 500 acres. Dad has inherited some from his dad. Mum's also got 40 acres that she received in settlement upon marriage. But we don't really know. We don't know what we should be worried about. There's a lot of confusing information out there, and we don't want to put ourselves on the back foot and get stuck in a position we don't want to be in.
And that's a good observation. Brilliant you've started to talk about it. And I think you mentioned earlier that you do the finances, so you've got the day-to-day overview. But the next question I normally ask people is, and this is really going to be for Laurie, it sounds awful, if there was a death yesterday, what would the tax bill be? What reliefs would be applicable? And then if there was a death after April 26, what would the new tax bill be? Because under the proposals, after the £1 million asset relief, effectively then, in most cases, after 325,000 nil rate band, it will be 20% tax on qualifying business assets. So I'll be honest, Laurie's done your accounts as a family for years, so he's got an overview. Equally, it may be, Laurie, you've not had chance yet to do that. So, Laurie, could you give me a feel for what you've been able to do? Because it was short notice to do this call.
Yeah, so it's a bit of a background to the family farming partnership. So in effect, it's mum, dad, and son. Obviously, Laura sits outside the business, as does her sister. Within the business itself, mum and dad own all of the asset equally. There's roughly 500 acres owned. They farm in total about 1,500. The remaining, obviously, the 1,000-acre difference is under contract farming arrangements and a few FBTs. And within that, all of the land that they own is sitting on the partnership balance sheet. We've got that, and it's all fully documented within the partner land capital accounts, albeit value-wise, it sits there at historical value. Obviously, mum and dad are in their 80s. We do have a partnership agreement, thankfully. We are often sometimes that isn't the case or hasn't been updated in a long while. So, as a scenario, if we work on the basis that we have, in addition to the land as well, there is a main farmhouse and a farm cottage. Main farmhouse, mum and dad reside in, and the son resides in the farm cottage with his wife and children. So roughly, if we work on relatively simple numbers, there's probably best part of £6.5 million worth of value, plus the bit of working capital on top of that. So you're nearer the 7.3 mark, give or take, overall for the family. So as it stands, if there was a death as of yesterday or today, the reliefs available would near enough cover all of the potential liability that could have arisen, given we've had unlimited APR and BPR. However, post April 2026, as you alluded to, the rules are set to change quite significantly, with a £1 million combined APR BPR cap per person. So what would be a fairly negligible potential inheritance tax liability would become fairly significant in this scenario. So as a broad brush, we haven't got the numbers down to a T, but ultimately you'd have two of that 7 and a bit of tax free, 100% relief. The remaining, we'll call it for round numbers, so it was 7 and 5. The remaining 5 would then be 50% relief. We're not accounting for the fact there might be some private and elements on the APR on the farmhouse, but ultimately they then got 2.5 million left before you apply any nil rate bands. So by the time you get down to 1.9 million, that's 40% of 1.9 million is quite a large amount of money. And so it's coming back to it really brings it to life with regards to, if we've got these large tax bills looming, that we need a strategy, we need the succession, and we need a plan in place. And ultimately that's where we're going now, because things need to start to move forward.
Yeah, and to some degree, I know Reeves's approach is appalling, but at least she's started the difficult conversations. A lot of farming families, my own included, have struggled with for decades. So, but it's the bad news is the tax bill. Can I just ask you, Laura? Before, when Laurie first rang me, he mentioned about the partnership accounts, and I think you may have seen those. Laurie popped a copy over to me in advance of this Teams call, and I noticed that there is quite a lot of money in what you call your mum and dad's current accounts. Forgive me for asking, but do you know the background to that at all?
No, so that was got to be one of my questions today, because I've seen the accounts and I can see my brother's got his share and parents have got theirs, but I don't really understand what that means in real terms of life.
Okay, and just before I cover that in more detail, Laurie, on your 7.3 million of value, do you reckon that includes those partners' current accounts, or are those in addition?
That would include the partner's current accounts in there as well. So there is working capital of the business that sits in there, which has been a main point of contention for many farmers, but given that a lot of their £1 million is taken up by the working capital before they even touch the land.
Effectively. And machinery, is that in the 7.3 or is that in addition? Because we all know how the machinery values are written down in the accounts, but actually on a death, obviously it's market value at the date of death, so they would be revalued at whatever the true value was at the date of death. Is there quite a bit of machinery? And I'm bearing in mind we've got a contract farming operation here as well running, and there's probably some quite big kit there owned by the business.
Yes, and at the moment that's based on a book value, because ultimately trying to decide where we are with market values of the full fixed asset register, we would need to go out to a valuer, which the values are going to be fairly busy off the back of the proposed changes. So ultimately there could be more value there than we've discussed, and that the kit's reasonably well written down. So there could be some uplift there, albeit it depends on what at the point in time the kit is valued and the general replacement policy. And ultimately Law runs the finances, so won't necessarily be involved in some of the decision making within the family farming partnership, albeit we'll see the invoices and we'll see the hire purchase agreements and other bits. So I think that's something just to be aware of within any type of business succession planning, is we've got to think of everything around, and you're right to point it out.
Exactly. Yeah, I mean, if we've got 500 owned acres here, we've got a farmyard, we've got 2 houses. If we took a very light 10,000 an acre, that's disregarding the hope value, because I think you mentioned about that 40 acres that your mother Laura received. Well, it was within a settlement. I don't know if the settlement's still around. That presumably is going to be worth more than 10,000 an acre. So some of these figures, I just wanted to give you a heads up, some of these figures that we're talking about do need detailed confirmation if we're going to do a precise calculation of moving assets around. And forgive me, I'm taking notes as we go through, so I'm not dozing off, but I just thought I'd mention, so from my notes, it is a bit of an issue. All right, thank you.
Yeah.
And I think within all this as well, as part of the planning matrix, that it'd be beneficial that all the advisors, myself and Jeanette, we've got maps of the farm, and we then use that to plot ownership, and we largely know the ownership. But as Jeanette and I well know, sometimes what is thought to be the ownership may not be the case. So if you've got those sorts of bits of information, or you would be welcome that shared with Jeanette in due course.
I can definitely do some digging. One of the issues we have had in the past is that we don't have one set family solicitor. We've had various different ones who have now passed away. So it may be a bit tricky trying to dig out some information, but of course I would do what I can.
Well, the good thing is you've had Laurie for many years as your accountant, and a lot of what we do is working really closely with the accountant, because if things are in the legal title names, it's not necessarily who really owns it, who's got the beneficial interest. And that will become clearer when we go through if there is any gifting to be done. If there's, for example, mortgages against the legal title, it may well be that we separate the legal and beneficial interest and effectively give away what we call beneficial interest. Think of it as sandwich together, legal on top, beneficial underneath. And then that is sufficient for capital gains tax and for succession planning, but it means that we can leave the top, the legal title, unaltered and still charged to the bank. The disadvantage is that the legal owner still remains liable to the bank, but 99.9%, and we can check this with you, times the whole partnership was already on the hook to the bank because they've signed a facility letter. So whilst the landowner has committed the mortgage against the deeds, in fact, the whole partnership is on the hook anyway. So moving forward, and I'm conscious that we've got quite a bit to cover here, again, just fact-finding a bit. who's really doing the farming, please, Laura? Is it your mum and dad who are in their 80s?
No, it is my
Thank
brother.
you.
Yeah,
Right. Okay.
they're sort of winding back a bit now. They are old, so he has taken on most of the work.
And how does he feel about this? The idea of having Laurie's huge tax bills land on him.
He may have mentioned that he doesn't feel it's completely fair. He's not, perhaps for the share work he's doing, he's not been rewarded equally with that, but he's paying tax on a different sort of percentage. So he's not unhappy, and he's obviously happy to sort of carry on the family's farm, but it has come up in conversation too that it's not balanced.
Has he thought how, in real terms, and this is where it gets quite painful, if there was a death yesterday, obviously they would be relievable, but if there's a death after April 26, how that tax bill would be paid? Are there any assets that we're not aware of so far that could be sold to pay a tax bill? Or are there any new income streams that are possible? Solar is very popular at the moment. It could be that. It could be you've got gravel extraction looming. It could be you're doing different things that we're not aware of. And forgive me, Laurie, I know you wanted to be brought up to date on this call. Laurie may not be aware of either.
Nothing has been mentioned to me. Like I say, I'm a bit more of an outsider, so I tend to see things done being told after rather than sort of consulted before. But that is probably a conversation that I do need to go back and have with them all.
And life policies, anything like that?
Not that I'm aware of.
Okay. It's just a question, as Laurie alluded earlier, we need to look at everything in the round to then give you a high level suggestion checklist as to what to do. The good news is you're well under the way you've got a written partnership agreement. So a lot of people in this country haven't got written partnership agreements. So you've avoided that horrible trap. The other thing which Laurie has alluded to is actually making it clear who owns what within the partnership. At the moment, I think, Laurie, you said that the 500 acres is valued at historic value at 200,000 in the balance sheet. Is that right?
Correct. Yeah,
Yeah.
we've got it at historical value. So coming back to your other point with regards to sort of excess value, in particular with the settlement that still exists, that was created in the 70s, that has got development opportunities. It's still reasonably early days. However, I think within the wider planning for the family, it comes up with that is tool in our armoury to find a fair approach to how the succession works and where assets eventually pass and where value passes down. But obviously that is impacted by the budget and the changes. So it's a tool in our armoury, and ultimately that will probably come towards those who are non-farming family members. I'm not saying anything that's given all the family get on. They're open about that, and I think it's something that is useful to have there in terms of it's the wider approach of succession planning is a form of wealth preservation, and in effect that is a helper in the fair but not always equal approach when it comes to asset allocation within families.
Yeah, and that's a really good point. I'll just build on that. The fair equality approach, that has been possible. It's been a luxury that a lot of farmers have been able to enjoy for 3 generations plus, nearly the last 40 years. However, the difficulty here, Laura, is in my head, because I'm not emotionally attached to your land. I'm also thinking, Laurie, on this call, potentially that 40 acres could pay a tax bill if it has got per acre a far greater amount of value than you'd get a return on the investment. And we all know the price of cereals at the moment is on the floor. We all know the input costs are huge. So, in terms of just focusing on how to pay the tax bill, could that possibly be an option to look at selling that land?
I think so. I mean, we're near the A11, so there's plenty of scope for development. So there are options, and that's what my granddad gave it to my mum for, with the idea of development in the future possibly. So I think we can consider it for sure.
Okay, so emotionally, that's a real
Yeah,
possibility then.
absolutely.
Good,
Yeah.
thank you. Okay, so just sort of put a circle around that. I think the other thing, just to bear in mind, I think Laurie, you said that it's actually in the corridor for the Cambridge Norwich expansion proposals. Just to get on your radar, there are proposals at the moment for compulsory purchase,
Okay.
which, if they come in, and they were brought in, funny enough, not by this government, but the previous government, but clauses which have yet to be enacted through with detail. So, from our point of view, it's also flagging to people if it has got the potential to fall under that definition. Don't keep it there as a certainty forever, because the way things move in politics, it could be you can't realise what we call the hope value, because under the proposals it would still be at a reasonable agricultural value. So I would just flag that. So it's sort of like a circle around that 40 acres, Laurie, perhaps, but with a caution. And I think that's time sensitive. It's going to be about realising the potential of that before those compulsory purchase provisions come in, particularly if, for example, it was needed for an infrastructure project. As well, it could be something to do with the offshore wind farm. It could be anything like that. It could be where you've got the compounds that are going through in North Norfolk as well for servicing those. So just flag it for you, Laura.
Thank you.
In terms of practical things to do, I'm sorry you've obviously had a few deaths in solicitors, and I do hope that doesn't bode the same way for me. But from my point of view, we'd be pleased to work through with you in more detail. My initial views are you could do with recording clearly in a legal document with all the existing partners' agreement exactly what is in the partnership in terms of land. And
Yeah.
we do that because it helps Laurie. If Laurie starts moving assets around, you've got a defined, agreed baseline. I know, Laurie, you've said in the accounts that there are full details of the fields in there with the title numbers, which is great. But I think you also mentioned there may be some unregistered land and some uncertainty exactly what the family owns. Is that right?
Yeah.
Okay. So what I would like, and we do this with everybody, is a copy of the latest available accounts and a plan showing all the land that you think you own. I'm happy for that to be based on an RPA map, but please fill in the bits that you aren't claiming on, obviously. And I don't mind if it's in two different maps. And what we do at Ashtons is we then run an AI program, and we figure out which bits are registered, which bits are registered and charged. And then we work through that, because the bit about the bank charges will influence Laurie's advice on a little tax called stamp duty land tax. So if we start giving anything away to the next generation and it's charged, we need to look at whether stamp duty land tax is payable on that. But I'm slightly jumping ahead a bit because you've got 3 partners in there at the moment, and I think Laurie said that everybody's got wills and lasting powers of attorney, which is brilliant for your parents particularly. Mind you, everybody should have them. I've got them. But I think also we need to look, your brother is doing the farming, but growing Laurie's point, this is why we need to have the meeting next with everybody, really. Well, certainly with your parents as the landowners, is figure out what they want to do about the non-farming children. That's you and your sister. Because, and this is where it gets a bit uncomfortable, really, but if in fact they want to focus on everything on the farming assets going down to your brother, if I put it like that, Laurie, you may well advise, because Laura's brother is in the partnership, that there could be some sensible gifting to effectively fill up his £1 million asset pot. But I'm also wondering, Laurie, about this settlement, because if it still exists, is there a possibility that we could use that as well with its own £1 million asset base?
I think there's still the possibility we can definitely use the trust. It depends on where we want to. We'll have to double check and go back to the trustees and the beneficiary pools, so whether we can actually use that sooner rather than later, if need be, subject to how it is all worded. But I think the use of the £1 million for Laura's brother is sensible. And what we haven't yet touched on is actually that Laura's brother has two children, two sons that work in the business as employed individuals. And so Laura's nephews are working in the business, so there is the opportunity that they could come in as partners. We haven't broached the topic with the family for a year. It usually comes up in the annual meeting as to whether what is the right point that they become partners. And I think it's previously there's been some concerns as to whether it's the right or wrong time. In all honesty, there is no right or wrong time. I think it has to be the right decision for the family, and ultimately all the partners have to agree on it. So I think it comes down to they're settled, and they're in their mid to late 30s. They've got partners themselves, so I think it probably is now more pertinent to probably try and push that through. And it comes down to if there's any offlying land as well that, albeit forms part, whether it's a ring fence, some of it is ring fence, but some of it isn't on the main site. So whether actually there are portions of land that could in future go down to Laura and her sister that could then still be rented back, or there's opportunities. But ultimately, we can, given the number of family members involved and potentially involved in the farm, that we have got the ability to weigh up using more individuals' £1 million balances, but ultimately, is the family going to be comfortable with having nephews that own £1 million worth of land? Ultimately, this is where the succession piece comes in, as you well know, Jeanette, that every family, albeit two farms might sound similar in size and operation, but the family dynamic and the differential is so stark that it's all a one size fits all. And I think, Laura, you probably understand that, having had this conversation just now and having Jeanette and I alongside one another, you can see the complexities that we are dealing with.
I didn't realise there were so many different routes as such. So yeah, definitely.
But what we're trying to do, Laura, is figure out what you as a family want to do as well. Agree with everything you've just said, Laurie, about potentially Laura's nephews coming in. There's also another layer, which is Laura and her sister coming in. And I think Laurie alluded to the fact that you've got significant independent private wealth of your own. So at the moment, Laurie, this is an unlimited partnership, isn't it?
Correct.
So we could potentially, if this works for the family, get engagement with the nephews, bring them into the business. And by the way, that you can bring somebody into a business, Laura, but you don't have to give them any land. So if you can think of two circles, and in the office, Laurie, as you know, I often draw two circles at this point. One is I carve up for the partnership and one is for the land. They don't have to be the same. And also a partner doesn't have to own land. So the beauty of what Laurie is suggesting would be you could, for example, bring the two nephews in, say at 1% profit and loss, and then they would be at the table if under the wills of your parents or indeed your brother as a partner, he decides to pass partnership assets to his sons. And the beauty of doing this is it's effectively a book entry. Yes, on a death, it would be taxable and taxable at market value, but it means you don't have to find the money to pay anybody out because the recipients are already partners in the business. But I touch on the fact you've got your own independent wealth, and it's not part of this call to go into that. But if your sister has her own independent wealth as well, the two of you may find it a bit unrelaxing to come in as unlimited partners, and you may want to limit your liability within the farming business because you're not doing the day-to-day farming. Perhaps you could come in as limited partners, and we can limit your liability to a monetary amount. It can be a relatively nominal amount of £100, £500. And it basically means if the unlimited partners go off and do something, your liability, your monetary liability, is therefore limited. And that attracts a lot of interest in people with independent wealth who may or may not want to come into the business, but feel worried otherwise about exposing their own assets to, let's be honest, quite an uncertain future in agriculture at the moment, Laurie, isn't it?
Yeah, and I completely agree. I think the option of limited partnerships are a useful planning tool, and I think are going to become much more prevalent where we're trying to sort of potentially spread wealth, and those other family members who've gone elsewhere in their career and built up their own pots of wealth, they want to protect themselves, but also they want to help the family in a way that helps protect a family farm in this scenario, protect the business, and protect it for generations. So we could end up with, in effect, 3 generations sitting in the partnership together, and how that is managed can be done through a limited partnership. You might have some that are going to be unlimited still, and those who come in could be limited. Especially if, Laura, if your brother doesn't want to expose your nephews to that liability, they might come in as limited to begin with, and then the dynamic may change in future. But ultimately, I think there is merit around that, and I think it's certainly something that we can discuss with the wider family, because I think it's something, it's a little bit different, a little bit quirky, and so I think having everyone round the table, and this is where the benefit of having your accountant tax advisor and your legal advisor in the same room together, you get more answers and we get more questions and more answers to move forward in a quicker manner and a more efficient manner, albeit there can be more expense around the table from having professional advisors there. Ultimately, there's less back and forth between Jeanette and I that would possibly take place following if we then ended up having separate meetings. So I think there's definitely a real benefit to that. And I think within all this, we have got a little bit of time on our side to put some planning in place, albeit I know mum and dad are in their 80s, so from that side it's a bit more difficult.
Yeah, I mean, they're in their 80s, Laura. I'm also a bit worried, as you know, about October 25 budget and what awaits as a next raft of goodies aimed directly at farmers.
Yeah.
And I'm also a bit worried about whether, Laura, your mum and dad can give anything away to fill up the £1 million pots, because the other thing we need to just quickly touch on in this call is what's called a gift with a reservation of benefit, so GROB. Sorry, I call it that because it's easy to remember then. But yeah, GROBs are to be avoided, because you can do a gift and you can still carry on taking the same amount of money out of business, but you cancel the efficacy of the gift for tax planning purposes. So the name of the game is to give away assets where you then cease taking the benefit out of those assets. Give you an illustration. If, for example, owned 50 acres and I needed all the income out of that, and let's assume that was £5,000 in total, but I actually, because Laurie's advice, want to give away half of that, I couldn't live on 2,500. So at that point, I could give the asset away, but it would not be treated as adequate for tax planning. So there's no point in me giving away. It's the worst possible scenario.
Yeah.
That's what we try and avoid any client doing, is giving the asset away, and then actually it's just disaster in
So
that case.
Live in their farmhouse. So
Yeah.
if I've understood this right, they couldn't gift that and still live in it, because that would have the same issue.
Yeah, they'd have to pay effectively a market rent. And I know it's a farmhouse, but it would have to look and smell like a proper rent.
Yeah, that makes
It couldn't
sense.
be one that you just sort of did as a bunch of mates between
Yeah.
you. It would have to be subject to a proper valuation, that would.
Yeah.
So it
There
could be.
are opportunities there, though.
I was going to say, this is where Laurie adds value a lot on this call. So, Laurie, could they live without the farm income? Are they drawing their profits out, or are they just rolling them up and building up their current accounts at the moment?
So they've built up their current accounts to a fairly healthy balance. Obviously, most of that is stuck within the working capital of the business. Within the profit shares, mum and dad have 25% each, and son has 50%. So from an income perspective, their income wouldn't change if we gave away half the farm, sitting within the partnership balance sheet, that is. So that is a tool in our armoury. Additionally, I suspect the ultimate end goal might be that your brother would end up in the farmhouse because he's natural succession, given he's been in the farm running the farm on behalf of the family for his lifetime. That mum and dad have the opportunity to do a house swap. They own the farm cottage and the farmhouse, but ultimately they would have the ability to give the farmhouse away and not pay any tax from doing so. Admittedly, the gift would stay in their estate for the next 7 years as a potentially exempt transfer, but on the disposal of the asset, albeit to connected parties between parents and son, there is the ability to claim the principal residence relief on any capital gain that would arise. So your brother would receive that property at today's market value as at the date of the transaction. So he's got that uplift. So that would be a way of beginning to start to strip some value out, albeit obviously that is a way of thinking about it. And ultimately, the farm cottage, albeit on site, might end up with a different family member or might stay with the farm. Again, this is conversations that we've got to have everyone around the table to understand what the aim of the game is, and actually we might say, you might say, or your sister might say, no, I don't want that. That needs to stay with the farm. But ultimately, it could be that if it were to be sold in the future, that you then get a divvy from it if that ever were to happen. So,
yeah, and that's exactly why we need this conversation, because they're the things we don't think about and need to know about.
Do they
Agreed.
have any pensions, your parents? I think you
No.
mentioned Laurie. Oh, Laurie thought they did. No, right. Okay, I misunderstood. Okay, so the income from the farm is all
Yeah.
their income, is it? Okay. In terms then of moving assets around, we will be looking at that GROB situation. So just to flag that for you. So in an ideal world, we'd fill up everybody's £1 million pots. However, we need to be mindful when we're gifting. But Laurie, from a point of view of gifting between spouses, how does that work from the gift with the reservation of benefit point?
So in effect, at the moment, given mum and dad own the assets equally, there isn't necessarily any change that we need to make on that. But ultimately, if it's going from one to the other, for example, if actually father owned more than mother, that if we gifted from father to mother, that they would actually, in order to actually still meet a qualification for APR, BPR, they've still got to have the ownership test met. So in that scenario, mother would then still need to own it for 2 years before she then would get APR, BPR if she were to go first. So that also needs to be considered in the round. But as a spousal transfer in any scenario, you have no capital gains tax, and from a IHT perspective, it's a spousal transfer, so it sits there, and they wouldn't be taxed until second death. But I think in the round here, we're getting to a stage where I think with the fact that there's more fact finding we've got to do with the family here, and more clarity. And I think it's been really useful to have this. I think there's a sort of, to wrap up, I'm conscious that Laurie, you've got another meeting to go to after this, and ultimately there are costs that come with this type of succession planning, and from our side there's costs to do all the calculations and the advice that comes with it, having had the meetings with the family, done the pre-work, the meeting and the post-meeting work, as well as the fact of having actually the legal input from Jeanette. And these types of discussions and meetings are complex and require a bit of time at the higher levels. But I think from a costing perspective, we can roughly suggest that we'd put a fee quote together, and it'd probably be the same for yourself, Jeanette, wouldn't it?
Yeah, I mean, the way we do it is I think Laurie had alluded to you before this call, we tend to charge for the time spent on these meetings, for reading in beforehand, preparatory notes afterwards, and as Laurie says, any immediate work out of that. But then, so that would be straightforward hourly rates. But then what we do at Ashtons is we prepare a fee scope email where we can. So if, for example, it's then clear that we're going to be doing a family meeting and we can put an hourly rate, etc. for that. Then out of that, I suspect we would do another fee scope email which said, these are the things we suggest you do. And I'm feeling, Laurie, at this stage, it looks to me a bit like some beneficial interest transfers. It looks like a deed of admission of potentially new partners. Query whether it's Laura and her sister or just the nephews. That's all subject, Laura, to Laurie working out the principles on that circle for the partnership. And then on the circle for the land, Laurie will work out, I reckon, what your tax bill would be for death after April 26, and then how to reduce that. And then I can price the transfer of the beneficial interests, because then once we've run the AI program on the registered titles, we'll know exactly what we're dealing with. And then we may need to price an element of sorting out the property ownership. If, for example, as you, I think, alluded to, Laurie, that there are some unregistered areas, because we need to be clear that you're giving away what you own. And also remember, if there is a death, HMRC are going to need evidence of everything. So it's getting prepared, really. But obviously, I know Laurie mentioned this on the earlier call, we still don't have any draft legislation. So what we're suggesting you do is do what you would normally do as a family, but perhaps on a death, but bring it forward now. But there are things to consider, the pros and cons of doing it now, which we need to go through in more detail. But that will be steered by you as a family, saying which route, which priorities you want. Is it equality between you, your sisters, and your brother? Is it maintaining the business in a viable form to enable it to carry on as a legacy of your parents? Is it to enable in your parents' lifetime to see succession to your nephews? All those things need to come out. And I know we're putting a lot on your shoulders as a family, and you're having to talk about a lot of things, and they're difficult. But to some degree, you are the drivers on this, all right, as well.
Completely understand. And I understand what you're saying in regards to the costings. I understand there'll be a lot of work from both of you. But I think as an outsider's point of view, I'd rather spend that money on putting plans in the future, so then we sort of don't pay a lot of tax in the future if we don't need to, if we can be a bit smarter of those things. It's just, I need to make sure the family understands that as well.
I think that's a very good point. And also cost benefit analysis, with Laurie running and perhaps putting an email, Laurie, across to Laura with what you think a post April 26 death of any partner looks like. Then at least that helps you, much the same way as growing a crop. You do a cost benefit analysis, you can figure out whether you can cope with that tax bill under the current ownership regime, the current partnership structure, or if you want to take control and do something, as you say, and spend some of that tax bill now and avoid the bigger tax bill later. All right.
Thank you.
Yeah, agreed. I think within all this, it comes back to saying that ultimately tax is going to be quite a significant shift in the value that we might have to be paying. But as Jeanette well knows, we don't necessarily want the tax tail to wag the dog. And it needs to be a fit that is right for the family and is right commercially. Just because doing it in a particular way might save the biggest amount of tax, but ultimately that then could cause complication for the next generation to then pass their bits down. So you've got to think multiple decades in advance in a way within this that I think is something that we haven't had to do and clients haven't had to do because of that, where the rules have been in a reasonably sort of benign IHT regime, because we've had unlimited relief. So it's quite a significant mind shift, and having the numbers in front of you allow you to actually understand it in more detail, have the information to hand to then make an informed decision, which is ultimately the ultimate goal here. So yeah, I think we're making progress.
Yeah,
and it's going in the right direction.
And Laurie, we've only on this call touched on inheritance tax. We haven't touched on capital gains tax, which also is one of the historic reasons everybody, the older generation, were told by all their professional advisors to carry on owning the land for the double uplift. But also, perhaps more immediate concern, Laura, is generating enough income for your parents and your brother to live on. And we're often asked, Laurie and I at the moment, well, should we just stop farming and sell up? Well, only if you can still get the same quality of life and lifestyle out of effectively investment income. And also you still created a very large inheritance tax problem at that point as well. So I think as a family, again, if I can perhaps, Laurie, put on their agenda, it's not just succession planning, it's priorities. Do they need income to live on? They haven't got any pensions or life policies. So what's going to happen if one of them's poorly or needs care? How are we going to deal with that as a family? We've got some quite big things here to think about on this one.
Yeah, no, I agree, and I think it's the succession discussions now, passing assets down from mum and dad to the next generation, or to between G1 from mum and dad to G2 of the children, or to the grandchildren, sort of G3. Ultimately, the inheritance tax issue doesn't go away, so that's probably then a challenge to Laura and your brother and sister that you've then got to think of, because you've got other wealth outside the farm. But how am I going to then cover my own liability? And similarly for those who are in terms of your nephews and wider family, that ultimately they need to consider how they would potentially take protections out now. So taking financial planning advice as well is essential. But I think that's a definite key. You've got a few things to think about, and it's doing it in a logical order. But I think it's the right time to be doing it, and we are where we are now, and we will be somewhere different in 6 months' time. So I think it's key, and starting the conversation now is beneficial to that. So,
and ideally get it done before October, please, because we don't know whether those reliefs, not headline rates for capital gains tax, but the reliefs, the stuff that Laurie and I can use to trigger, that we can avoid triggering a payment now of a capital gains tax bill in some cases. But again, as Laurie said earlier in this call, we need to look at the pros and cons, because it doesn't always work for everybody, particularly if you're looking at development land, if that is likely to be sold within the next 12 months as well. But we need to put all the facts to you. And as a family, you need to come to us with the principles, and then we can put the two together.
Yeah, that makes sense. I definitely think we need to have another discussion, and I need to bring them to you so we can all talk together. There's a lot that's come out of this that I think they need to listen to.
Okay,
brilliant.
Thank you.
Hi, I'm back again. So if you made it to the end, congratulations, you did very well. In all seriousness, I hope you got some useful insights from that case study. Don't forget, if you find yourself in a situation where you aren't sure in what you need to do, then please do get in touch. Our contact details, as well as Jeanette's, will be in the show notes.
Thank you for joining us for Larking Gowen Insights, Accountancy and Business Advice for All. Don't forget, you can find more information about today's topic and more about how our team of experts can help you in your business by visiting our website larking-gowen.co.uk. Join us again next time for another fascinating insight into the world of accounting and finance.